Okay. All right, go ahead.
Okay, well, good morning, everybody. My name is Bill Z. Actually, the last name is pronounced just like the last of the alphabet. I'm a business advisor from the Stony Brook Business Development Center, and I'll tell you more about what we do at the end of the presentation. And right now, I'd like to give Erin and Will, our presenters, a chance to introduce themselves and get on with their presentations. This is a very interesting subject matter, and I think it's near and dear to a lot of our hearts. So Erin, take it away.
Good morning, everybody. Thank you for having me here. My name is Erin Trong. I am an attorney with the law firm of Losa & Losa. It has offices all across the US, handling patent, copyright, trademark matters. My particular focus is in trademarks and copyrights. I specifically handle all aspects of applications, enforcement, and litigation. Been doing this for about 15 years or so. My office is based in New York, so happy to have a conversation and discussion about intellectual property. Thank you for having me here.
Will, I think it's your turn.
Okay. Am I on screen?
Yes, you are.
Oh, sorry about the delay. Happy New Year, everyone. It's great to be here with this wonderful group. Looking forward to the presentation. My name is Will Salas. I'm a librarian first, but we wear a lot of hats. One of the hats I wear is a Patent and Trademark Resource Center representative. I work with the United States Patent and Trademark Office. We are accredited to help give out information about patents and trademarks. And one of the most valuable things that we have to offer here at the Smithtown Library for free are demonstrations of a patentability search and demonstration of a trademark search. So if you wake up one morning, you have that brilliant idea that's going to change the world, and you wonder what you're going to do next, well, you can come visit with me or Miss Erin, and we'll see what we can do for you. And we'll talk a little bit more about patents after Miss Erin gives her presentation. Okay, back to Erin.
Okay. All right, so I am going to go share my screen right now. Okay, can everybody see my screen right now?
Yes, we can.
Okay, great.
Perfect.
Okay, so we're going to jump right into it. My topic area is trademarks and copyright. Let me minimize this, I'm sorry. Oops, okay, all right. All right, trademarks. So we are surrounded by trademarks every day. It's in our goods, it's in our services that we use. We might not notice it, but it is there. It is essentially the branding of a company. When you see a brand, you see a trademark, it is the goodwill behind a company. Sometimes you see a brand and you attribute certain qualities. Sometimes you see a brand and you attribute negative qualities. It's essentially what trademarks are. It is the goodwill, that's what we call goodwill, behind a mark. So let's get into the definition of a trademark. So the definition of a trademark is that it's essentially a word, phrase, symbol, or even a design or combination that identifies and distinguishes one person's goods from another person. A trademark is the exclusive right to use that mark in connection with that goods or services. I do want to point out that trademark rights depend on the certain goods or services that it is associated with. So for example, if somebody has a trademark for X, Y, and Z on televisions, that means that another trademark can potentially coexist with that first trademark if it is in different goods or services. So for example, if it's on cosmetics, for example, that is coexistence could potentially be acceptable. The reason is because it's dependent on the certain goods and services connected with that trademark. I do want to point out also that trademark rights are territorial. Your use in the US and your rights in the US are US based. If you're looking to secure rights in Canada or another country, then you should be trying to seek registration in those countries and obtaining protection there. Okay. Now, I'm not sure. Can you? There you go. Common law trademarks. So in the US, there are two bases to obtain trademark rights. One is based on common law and one is based on federal trademark registration. Under common law, trademarks are based on your use of the mark in commerce in connection with those goods and services. No registration is required and priority is established by the date you first use that mark in commerce. So that is common law rights, and there's no registration required in that situation. All you need to do is use the mark in commerce in connection with your goods, and your protection is automatic under common law. However, it could be limited to that geographical region. Now, that's the reason why federal trademark registration is beneficial, is because you have more rights and more benefits once you apply for and obtain a trademark registration. So in terms of applying for trademark rights, it's not required, but you do obtain several benefits and advantages if you do. Once you obtain the registration, it is public notice of your claim of rights to that mark. Your mark is found on a USPTO database. Having a registration is the presumption that your ownership is valid nationwide in connection with those goods and services. You can bring an action in federal court and obtain statutory damages for an infringement. Obtaining a registration is also a basis of obtaining registration in other foreign countries, and you're able to even submit your registration to the Customs and Border Protection Service to prevent importation of infringing goods as well. Number 6, you've seen also on trademarks that there is an R and a circle around it. That means that the mark is a registered trademark. If it is not a registered trademark, sometimes you'll see a TM after it. That just means that it is noticed that somebody is claiming trademark rights to it. It could be common law trademark rights, but when you obtain federal registration, the symbol R is recommended when you actually do get a registration. And the last point is that your mark, which is similar to the first, is listed on the USPTO online database. So anybody searching for your mark will be able to see that, and anybody applying for a mark that may be confusingly similar will be prevented from obtaining that mark if you have a federal registration. Okay, how do you go about applying for a trademark? You can do that all online with the US Patent and Trademark Office. It is at uspto.gov. It is a very informative website. It has a lot of information as to tutorials, trademark basics, some videos as well as to how you go about applying for a trademark. There is a tab with the USPTO for trademarks. If you go under that tab, you'll be able to see information as to trademark basics, the application process. This is where you would go to apply for a trademark. Everything can be done online. You don't have to mail anything in anymore. And then there are ways, once you obtain your registration, to file continuing renewal maintenance of your registration as well. Okay. I'll go over some basics as to when you're applying for trademarks, they're going to ask for a lot of information, and there's different types of trademarks that you can apply for. There are generally two types of trademarks. One is a standard character mark, and that type of mark is the word written as itself, for example, Coca-Cola or Coke. Standard character marks are the broadest level of protection you can get. It provides you flexibility to use the mark in any stylistic way. You're not limited to the font, the color, anything like that. It is the broadest level of protection, and that's what is recommended, especially if you're starting off. You want to try to obtain the standard character mark registration, because if you're not set on your logo or your design yet, you should be looking at the standard character mark. The second type of mark is a design mark. It is essentially a logo, if you want to say, where it represents the stylistic appearance of your mark. I put an example as Coca-Cola, the stylistic script up there. Coca-Cola also has a registration for their bottle, the dynamic ribbon. They actually have registrations for that. Thing to keep in mind with design marks is that you're limited to the exact same representation of that logo as you applied for. So if you're claiming color, you have to stay consistent with your color usage. The script, you have to stay consistent with it. So you're limited to the exact same stylistic appearance as how you applied for that mark, and it's pretty restrictive. You have to stay consistent, but that essentially makes sense if you're trying to gain consumer recognition to that particular logo in connection with your goods and services. So it is a little bit more restrictive, but if you're set on already a logo that you want to use in commerce, then a design mark would be the way to go at that. Okay, standards for registration. So to obtain a registration on the principal register, which is the primary register with the USPTO, the mark has to be strong and distinctive and unique when it comes to your use of the mark in your connection with your goods or services. And also the mark cannot be confused with another mark that's registered with the USPTO or a prior filed application. So what happens is once you file your application, an examiner gets assigned to your application, and he or she conducts a search on the USPTO as to whether or not there are other marks that are registered or any prior filed application that are similar to your mark. And if there is, then he or she may issue a refusal or an office action. That's what it's called, refusing your mark as being confusingly similar. Now, the mark also has to be unique as well, which means that the mark has to be distinctive. It has to be a strong mark. Now, I've also provided on here examples as to what a strong and weak mark are. There are generally four types of marks. One is a fanciful mark. Second one is suggestive. The third is descriptive, and the fourth is generic marks. I'll go through each one of them real briefly. Fanciful marks are the strongest marks and the most protectable because they are distinctive. They are arbitrary words. There's no dictionary meanings in connection with those goods and services. So some examples would be Belmico for insurance services. So when you see that mark, you don't automatically think of insurance. Apple is the same way. Even though Apple is a known word, we know it for apples as in the fruit, but we don't necessarily know them for computers. So Apple is considered to be a fanciful arbitrary mark, which is given the most deference to because it is inherently distinctive. So when you're looking to brand your product, you want to try to come up with the most unique name for your mark, and that gives you the most it gives you the higher potential that your mark will be registered with the USPTO. The second type of marks is where most people get into, which is the suggestive mark. Suggestive marks don't necessarily describe the goods or services, but it gives a little hint as to what it is. Some examples are quick and neat for pie crust or glance a day for calendars. It gives a little hint as to what potentially your goods or services are, but it doesn't describe it. Now, descriptive marks are a little tricky because sometimes descriptive marks could be arguably suggestive and can obtain registration, but descriptive marks, if they're considered merely descriptive, then they are not registrable with the trademark office. This is because it's describing a characteristic or a feature of the mark, and the trademark office does not want to give you rights and prevent other people from using that mark in connection with their goods and services. So descriptive marks, example is creamy for yogurt, which describes the characteristic of the product, or world's best bagels for bagels. They're not registrable because they are merely descriptive. Now, with descriptive marks, there is an option I'll talk about in a little bit as to obtaining registration on the supplemental register, which is a step down for the principal register. If you're on the supplemental register and you've used a mark in commerce for a 5-year period and you can prove that it acquired distinctiveness, which means that consumer recognize world's best bagels for your bagels, then you can obtain registration on a principal register after that 5 years of use in commerce and demonstration that it acquired distinctiveness. The last type of marks is generic marks. These are marks that are never registrable and not enforceable because they are very just generic. They're marks that are used for everyday products, and the trademark office does not want to limit anybody from using it because it is generic. Milk for dairy products, bicycle for bicycle shops, those types of marks are considered generic, and you cannot obtain registration for those type of marks. Now, the Uspto registers, I mentioned this before, there are 2 registers with the Uspto. One is the principal register, and that is a register for marks that are distinctive. They've met the threshold in terms of distinctiveness, and they are considered to be the marks that have achieved distinctiveness. The second type of register is the supplemental register, and those are marks that are descriptive in nature, and they can achieve distinctiveness if they have been on the register for 5 years. So I consider the supplemental register as an incubator for descriptive marks. There are benefits to being on the supplemental register, such as your ability to use the R symbols. You can sue for infringement if you're on the supplemental register. So if you're on the supplemental register for 5 years or so, then you can apply. It would require another application process, but you can apply at that after the 5-year mark to registration on the principal register. So there are some benefits if you can't get onto the principal register. Okay, identification of goods and services. So this is a very important part of the application process. The US uses the same international classification system. There are 45 different classes, 34 for goods and 11 covers services. In the description of goods and services, which is required in the application, you have to specifically identify the particular goods and services associated with your goods. And this is important because your rights would be dependent on those goods and services or services you identify. So you want to be careful in terms of describing your goods and services on your application, and making sure that your application covers the goods or services that you want protection on. Okay. All right. Okay. So once you obtain a registration, how long does it last? Essentially, a trademark registration can last forever, as long as you continue using that mark in commerce in connection with your goods and services. There are continuing renewal requirements that you have to file with the Trademark Office, but the first renewal filing is not due until the 5th and 6th year of registration. And then thereafter, it is before the end of the 10-year period after registration. So it is a lengthy amount of time that you get in terms of your trademark registration rights. It's just you have to continue to maintain that registration with the USPTO and also provide proof that you're continuing to use the mark in commerce. But essentially, they can last forever as long as you continue to maintain it. And all the maintenance is done with online with the USPTO. Okay. We'll move to copyrights. Copyright essentially protects works of authorship, writings, music, works of art that have been tangibly expressed. It grants the author exclusive rights to that work. And in terms of what rights are with copyrights, it's the right to reproduce the work, to prepare derivative works, distribute the work, publicly perform the work, and also display the work. So there are a lot of copyright rights that you can obtain, and these rights are actually automatically protected, similar to trademarks. So once you create that original piece of work, it is protected the moment you create it and you put it onto a tangible medium. So for example, if you have an art sketch and you put it on a piece of paper and you're finished with it, that is considered, you are considered done with that piece of work, and your copyright protection automatically exists as soon as you create that original piece of work. So you do have automatic copyright protection as soon as you create the work, but registration has its benefits and it is recommended, especially in terms of enforcement of your copyright. Okay. Enforcement of your copyright, it allows for statutory damages and also attorney's fees if you were to bring an action in court. Copyright registration, having that piece of paper also is prima facie evidence of your validity, and it gives you proof, especially if you're sending a cease and desist letter to somebody and you want them to stop and take down your original work, then having that original registration certificate helps in that enforcement. Also, same as copyrights, you are able to record that registration certificate with the US Customs Office, and that prevents importation of infringing works as well. Okay, so to go about applying for and obtaining a copyright registration, it is with the US Copyright Office. It's copyright.gov. Similar to the Trademark Office, it is very informative. It has a lot of information as to frequently asked questions, information as to how you would register your work. You do have to set up an account with the Copyright Office, but it is very straightforward. Everything is done online. You apply and submit your application, and you also would submit deposits, which is copies of your work with the Copyright Office, and everything can be done online. Okay, for the standards of registration of a copyright, it has to be original. It has to have some degree of minimal creativity. So take, for example, literary works, musical works, sculptural works, all of those things. If they are original, if they have some degree of creativity, then it can be registered. I do have to note in there that compilations can be registered. However, take, for example, telephone directories. It it has been determined that telephone directories do not satisfy the creativity requirement for registration. This is because there's the court has determined that there's no ability to determine the order of how telephone directories are listed. There's no creativity involved in terms of selection of the names, who is included, and so forth. So compulations, although they are registrable, if there is some creativity element to it, in the most part, if you're looking at telephone directories, that type of work is not registrable because it's not creative enough. Okay, so copyright duration, it really depends, because it depends on the publication, when it was created, and whether or not it was a work for hire. Now, a work for hire is something that is created for a company. So there's a whole nuance on that situation, but in general, if it is a piece of work that you created and it's today for works after 2002, the duration is 70 years after the death of that particular author. Now, if it is a work made for a corporation, a work for hire, then it's 95 years from publication, which means it is available or published with in the US where people can see it. It's 95 years from publication or 120 years from creation, whichever comes first. Okay, so in terms of takeaways, trademark, think of trademark as protecting words, symbols that identify the source of the goods from one party or the next. Copyright protects original works of authorship, such as books, literary works, and then patents protect inventions and discoveries. So I know that's a lot to digest in the 30 minutes, but that's a takeaway if you were to take anything away from that. But we'll talk about patents in terms of inventions and discoveries next.
Yeah, in a little while.
Okay, I just want to ask you, somebody gave me a project, I just want to work on it, but I have to get back.
Yeah, sure.
Okay, am I on screen, Bill?
Yes, you are.
Fantastic. I'm going to share my screen, folks. Thanks again. Well done, Erin. It was a really great presentation. Erin also works with patents. I also work with trademarks. So if you have any questions about trademarks, especially if you want to see a demonstration of the trademark electronic search system, I can give you a quick demo. Again, I don't give legal advice. I'm not an attorney, as Erin is, but I will show you through examples how to perform a preliminary trademark search. But today I'm going to transition and talk to you about patents. Okay, now the reason that I'm speaking to you is because the authority when it comes to patents in the United States is, of course, the United States Patent and Trademark Office. When it comes to patent searching, there's a lot of other games in town, but I like to work with the authority, the organization that really organizes and creates the information. Remember, my first hat that I wear is a librarian, so I'm very careful about the information that I work with. And when it comes to patents, the authority is definitely the United States Patent and Trademark Office. Now, the reason I'm talking to you is because there is such a thing called a Patent and Trademark Resource Center. So basically, what that means is that the patent office, it behooves them to get the word out about patents. They thrive off of their application fees and their maintenance fees. So obviously they want to get the word out to more people about the protections that patents offer people and why they should get one. And we help in that regard. We're all over the country, and a little later I'll show you a map. You may have heard of us before as referred to as a patent and trademark depository library, but thank goodness there's not too much actually deposited anymore. Everything's moved into digital format, so that makes it possible for me to have a patent and trademark resource center. Otherwise, I'd have reams and reams and hallways full of patent documents. So one of the things that are unique to a patent and trademark resource center is plant patents. Just as I say everything's transitioned to digital, I kind of lied. Plant patents still come in paper format. And the reason that is that what differentiates one plant, and when I say plant patents, I literally mean your roses, your trees, your shrubs, your fruits, your berries. Plant patents protect inventors who are able to asexually reproduce a new variety of plant. Now, to distinguish between the two, oftentimes texture and color is very important between a new variety of plant. So for that reason, patent and trademark resource centers like mine have plant patents delivered still in paper format. We actually get photographs of the patents. A lot of my colleagues are uploading them onto websites, which is wonderful for a preliminary search. But again, when you view one thing on one screen and then another screen, computer monitors are often slightly different from one another. So it could deteriorate from the actual accuracy of the actual photograph. So that's why we still have plant patents in paper format at libraries like mine. Now, one of the things that at the PTRC, we get all kinds of folks. We get moms, we get doctors, we get professionals like Erin. And we have something for everyone. One of the things that some of the professionals like attorneys and engineers use is our special database. It's called Pub East, Public Examiner Assisted Search Tool, and Pub West, Public Web Examiner Search Tool. These are two of the databases that are actually used by patent examiners themselves at the USPTO to do patent searching. And they require a lot of security because we're actually logging into the server at the USPTO. So access to these databases is very rare. But if you live in the Suffolk County area or even Nassau County, you're welcome to use it. It is very clunky, industrial looking. And if you don't know how to use it, it can be a little difficult to wield. But a lot of professionals out there who are familiar with it are welcome to use it at the Smithtown Library. One of the other things we offer is programming from time to time. In the age of the pandemic, we don't really have much programming, but soon we hope to be able to start welcoming groups of people back into the library for patent and trademark programming. But the real jewel of what patent and trademark resource centers offer to everyday people are demonstrations. So like I said earlier, if you have that idea, you wake up and you have a great idea, you don't know where to go next, visit a patent and trademark resource center because we can get you started on the patentability search. Again, I don't give legal or business advice, so I show you by example how to perform a preliminary patent search. And by preliminary, we mean we show you how to, we demonstrate how to search the top 3 patent databases around the world, the US, the European, and the Japanese. And by then you get the hang of it and you can start to use what I have shown you and demonstrated for you for your own invention, your own device. And again, we are officially designated by the United States Patent and Trademark Office, so we get an annual training and access to those special databases. So like I said, there are patent and trademark resource centers around the country. And the closest one to you in Suffolk County is me at the Smithtown Library. I'm in my office now, so I will meet with you in person, but if you prefer to stay home, I will meet with you through Google Meets. You see my contact information down there at the bottom. At the very end of my presentation, I'll leave a screen up with my contact information. And again, we don't charge anything for our services here. So we're going to talk about ideas. That great idea that you have that's going to change the world. So someone a long time ago said that, well, necessity is the mother of invention, which is very true. A lot of the people who come in to visit with me are problem solvers. And if you solve a problem and you have a device or machine or something that can help you solve a problem that everyday people have, then you might have yourself a pretty good invention there. For instance, sometimes you want to live in a world where you don't have to choose between just one thing or another. And if you're a tinkerer, you like to, you're good with your hands, you might invent something and say, hey, this could be something that I could sell to others. It could be. Now, in full disclosure, not every idea is patentable and not every patent becomes a commercial success because there are all kinds of wacky ideas out there. But I'm not here to tell you what's a good idea and what's a bad idea. That's up to you because a patent can help. But once you get that patent, you got to do a lot of marketing and get out there and get the word out about your product. And you have to hype it. You have to advertise it. And that's the kind of thing you want to visit a small business development center for. They're the ones who would be able to help you on that end. Now, what exactly is a patent? So you have that great idea. Now you want to protect it. You don't want to tell everyone your idea before you have some kind of protection, because ideas do get stolen. And to protect an invention idea, you would get to seek a patent, which is a government grant that says you are the inventor and that only you have the right to make your invention, use it, offer it for sale, or sell it, your invention, in the United States and its territories. Now, I mentioned earlier there are patent offices around the world, and if you get a United States patent granted, that's wonderful, but you're only protected in the United States and its territories. A lot of inventors find out the hard way that they do get a US patent, and then they want to manufacture their product for cheap. So let's say they hire a Mexican manufacturer or a Chinese manufacturer or elsewhere. If the manufacturer really likes your idea, they can manufacture more than your order and sell theirs to their countrymen, because you're only protected for your device in the United States and its territories. You can seek patent protection in other markets around the world, but you would have to apply separately to those patent offices. Okay, so not everything is patentable, and there are 4 requirements that your device has to meet to be patentable. The first is it has to be in a statutory class. So what does that mean? Well, it has to be a new process or a new method. Think apps and computers. It has to be a new machine. It's got moving parts. A new article of manufacture, which I don't know if I'm still on screen, but a new article of manufacture may be something like a pencil where there are no moving parts. New composition, or many times you're created something that's new and useful that had already existed, improvements to a pencil or an umbrella or roller skates. That could also be patented. Your invention has to have utility. It has to have some function. Some of us are vague and we want to add to our trophy wall, so we try to get a US patent by throwing a bunch of nuts and bolts together and say, hey, look, this is a new invention. No one's ever done it before. Well, I might say, sir, that might be sculpture, but it has to have some functionality for it to be a patent. Now, thirdly, your invention has to be novel, new to the whole world. Now, that seems to stun a lot of people who visit with me because they think they only have to clear it, make sure it's not in the United States. They don't find it on Amazon.com, but not so. Your invention has to be new to the entire world, not just patent offices. It cannot be sold anywhere, published anywhere. Your application, let's say for a mousetrap, will land on the desk of a patent examiner who is an expert on mousetraps. And he or she will know all the trade shows, the trade magazines, websites, and certainly all the patent offices. And if that patent examiner finds that the technology that you think is new for your mousetrap was published or is being sold in South America or in Europe somewhere, that could be enough to deny you claims for a brand new invention. And the fourth requirement is your invention has to be non-obvious. That's a little difficult to explain. What that means is that somebody who is familiar with your industry cannot have anticipated your invention. There has to be like an aha moment, like, oh, I didn't think of that. Think people who make bicycles. So let's say you're a bicycle manufacturer, and then someone comes out with a brand new, stronger aluminum metal, and you decide, oh, I'm going to be the first one to build a bike frame out of that new metal aluminum. Well, that was kind of anticipated. You didn't really do anything differently but to use a brand new material. So that probably wouldn't qualify as a patent because it would have been obvious to someone who's skilled in bicycle making, bicycle frame making. So what cannot be patented? Well, perpetual motion machines cannot be patented. Categorically, those inventions are turned down, and I'm not so sure if that's the greatest idea. The idea is that would defy physics, so it's impossible. But depending on who you ask, anything can be possible. But the patent office does not consider perpetual motion machines. It's against physics, so they won't patent those things. Abstract ideas, the patent office, they don't want to be the thought police. They don't want to stop you from thinking of things abstractly. So abstract ideas cannot be patented. Also, things that belong to everyone, natural or physical processes, scientific truths, mathematical expressions, they belong to everyone. So it's part of our natural world, and we're not interested, the patents office is not interested in stopping anyone from using anything that should be shared by everyone because it comes from nature. And inventions, of course, which could be harmful to the public and detrimental to national security, is not patentable. Alrighty, so let's talk about the give and takes of the patents. Why would you want one? Well, if you do get a patent granted to you, you're going to get a government grant from the United States that says, yes, in fact, you are the sole inventor of this device, unless you had invented it with others and they're listed. And you are going to get a 20-year legal monopoly on your device. It'll only be 15 years if it's a design patent, and I'll go into the differences between the two a little later. So that 20-year or 15-year monopoly means that you're the only one who in the United States and its territories that's able to make it or use it, import it, or sell it in the United States. Now that's a two-way street. You, the inventor, get that monopoly so that you can capitalize on all that hard work and research and prototypes that you were creating for years. Now you finally have a device. So we want you to be able to capitalize on all the hard work that you had done for 20 years. But at the same time, the government is going to get something. You have to fully disclose how your invention works, and that's going to become a public domain document at the USPTO.gov website for everyone to see. And people will see it because there are other people who are looking into inventions similar to yours. They also want to find out what you're up to. And when they see your documents, they're going to be able to innovate based on what you had created. Now, you're still protected with your invention, but you're also going to be showing how your invention works, which stimulates innovation, which then stimulates the economy. And that's what the government wants, is to stimulate the economy. Let your invention be discovered, seen, but no one can actually infringe upon your invention, but you are inspiring others with your technology. So there are actually 3 different types of patents. Most of the times when you hear anyone talking about a patent, they're talking about what's called a utility patent. And this is going to sound familiar. A utility patent is any new and useful process or method, a new machine, a new article of manufacture, a new composition of matter, or any new and useful improvement. Again, this is the most common patent out there. And if you see a patent document that has just figures and no numbers, letters in front of them, that is a utility patent. Next, we're going to talk about design patents. Design patents protects the ornamental design of a product, the appearance, and the patent number will be preceded by a letter D. Now, I have an iPod in the screen there. Whenever I think of design patents, I think of Steve Jobs. Steve Jobs was a brilliant man, but his patent collection was mostly design patents under his name. He would design, these MP3 players with rounded curves and rounded buttons, and that's what he was protecting, his design. And then he would have others invent all the working functionality parts of it. But his designs were his patents are mostly design patents. And I mentioned plant patents earlier. When you see a plant patent number, it's preceded by the double P. And yeah, you can have a patent on a brand new plant as long as it's asexually reproduced and it's distinctive from other varieties. I get them all the time. They're actually kind of fun to work with. The young man who files them for me has become quite fond of them. They're very colorful, they're very lovely, and they're very interesting. So some people want to know, how much is this going to cost me? Which is a very legitimate question. So outside of any legal fees, the fees to the United States Patent and Trademark Office are on screen here. Now in the first column here, you'll see the explanation of what the fees are for. And then we have 3 other columns, one a regular fee, then we have something called a small entity fee, and they're getting a 50% discount. Then still further on the far right, you have what's called a micro entity, and they're getting a 75% discount. Well, wouldn't we all like to be a micro entity? Let me explain what they are. The regular fees are for your businesses and corporations. Now, the small entity column with the 50% discount, those are for your nonprofits, your universities, perhaps some individuals. And again, the patent office really wants to get out there and attract everyday people to start filing their ideas for invention. So they created what's called a micro entity that gets 75% discount on patent and trademark fees. Now, to qualify for a micro entity, you have to have certain requirements. Based on income, you have to make less than 3 times the national median income. The last time I worked it out was roughly about $205,000 the tax year prior to your application. So if you're applying today in 2022, your 2021 taxes have to show that your income was less than 3 times the national median income. Also, they want to reach out to the new people. So if you have your name on 4 or more previous patent applications, then you're no longer going to qualify as a micro entity. And finally, you have to employ less than 500 people. Again, they're trying to reach out to some new people, everyday people. Also, if you are working for a corporation and you're beholden to share your patent with that corporation, well, you're not going to qualify as a micro entity because you have to share that patent with an organization that may not qualify as a micro entity. Oh, so the provisional patent application. So this is your first level of defense to protect your idea. The provisional patent application is kind of like a watered down regular patent application. It's fairly cheap. It's $300 for regular fees. For small entities, it's $150. And for micro entities, it will only be $75. And what the provisional patent application does is that it allows you to timestamp that Will Salas had this idea on January 13th, 2022. And then it allows me a year's time to file my regular patent application. In that year's time, I'm going to do a patentability search. I'm going to talk to people like Leslie and Bill at the Small Business Development Center. They can give me a better idea. Does my idea really have legs? Is there an audience for my idea? Can I make my product and actually make profit? Is it sellable? Also, during that time, I'm going to do a patentability search. I would visit a patent and trademark resource center. Again, I don't know if I mentioned it earlier, but if you file for a patent application and it turns out that the patent examiner is able to find your technology exists elsewhere, you don't get those application fees back. They keep them. So it's always very wise to do a search first. I've had people come and visit me and say, oh, well, the patent office is going to search anyhow. Why should I bother? You should bother because if you care to hold on to that money that to apply, then you want to do a search first. There's a whole industry of attorneys that will do the searching for you. If you visit with me, I'll give you an idea about how to begin your searching, and then you'll be a better client for your attorney because you'll know more about what they're going to be doing for you. Also, if you file a provisional patent application, as soon as you file that, you'll be able to place patent pending upon your product if you've already got a product. Also, when you have a provisional patent application, you can feel more comfortable about showing and selling and publishing your invention, because if someone tries to file a provisional patent application of their own with your technology, months, days, or years after your provisional patent application, you have the earlier filing date. And in the United States, we have a first to file system, meaning if there are a dozen inventors and tinkerers and entrepreneurs and business and scientists out there who are all thinking of the same kind of an idea for the same invention, it is the first one to file that provisional patent application and articulate it well enough that will most likely get the patent should it be filed. Also, filing a provisional patent application also buys you an extra year. What will happen is you file your provisional patent application, and then roughly a year later, you file your regular patent application. Once your regular patent application has been processed and granted, you get those 20 years, but you also get backdated the year that you had filed your provisional patent application. So you're going to get 21 years of protection out of it. Also, your provisional patent application, you can file one right away, but if your invention idea begins to flesh itself out and you think of better ways to solve that problem that you had solved, you're not going to be protected for anything that's not included in your provisional patent application, but you can file yet another provisional patent application to cover those changes that had happened. And then you'll be covered for those changes for a year's time. So when you do file for a provisional patent and you do a search, what you're searching for is prior art. You want to make sure no one in the world has already beaten you to that technology. Now, everyone likes to perform keyword searching, and I do too as a librarian. Who doesn't like Google or Bing or Yahoo? But what I show people, and what is shown to me by the United States Patent and Trademark Office, is to perform a classification search. What classification does, it brings like things together that makes browsing easier. If you were to visit me at the library, and I'll show you a little later, and you wanted to find a book on personal finance, I would give you a call number 330. You would walk up to the stacks where all the books are, look on the binders, you would find the number 330 on the binder, and lo and behold, you would find yourself in front of the personal finance books. You wanted to find a book on coaching girls soccer, I would give you a call number of 796. You'd use that number to go back up to the stacks, find the books with 796 on the binder, and you're in front of the coaching soccer books. Same thing with the patent office. They get thousands of different types of gizmos thrown at them every year, from mouse traps to fuel cells to rocket ships. What the patent office does is they push and prod all of those inventions into classes, sometimes several classifications. So as an inventor, your job is to find out and figure out, well, what classification would I use for my invention idea? And once you have that classification, you have that filter to go into the United States Patent and Trademark Office's database and find similar inventions to yours, then comb through them to see if anyone's beaten to your technology. Now, the Patent Office is very proud of themselves. 2 summers ago, they issued their 10 millionth patent, which is wonderful for them. Not so wonderful for an inventor who is trying to find their invention amongst that haystack. Keyword searching is possible after 1976 at the uspto.gov database, but before then, you cannot do keyword searching. If you prefer to do keyword searching, there are other products out there, like Google Patents will allow you to do keyword searching and other databases as well. If you come and visit with me, I can introduce you to some of them. So like I said, when you are doing your patentability search, you're not going to just stop at the United States Patent Office, European Patent Office, and Japanese Office. Those are just the ones that I will demonstrate for you, but you really need to do a global search, and if you hire an attorney, they will as well. Now, when it comes to searching, like I had mentioned earlier, classification is a really great way to begin your searching. Now, I had given an example earlier about if I get a visitor at the library and they wanted a cookbook, or they wanted a coaching book or a personal finance book, I give them a call number. Let's go through an example like that as well. So let's say you wanted to study baby cribs, and you visit the library and you wanted books on cribs. Well, then I would give you a call number of 684.1, because I would use my catalog and I would find that it belongs in that area. So baby cribs, well, all books on baby cribs will be given 684.1. So when I go up to the stacks and I go to that number, I know I'm in front of all the books that include baby cribs. Same thing with the Patent Office, but they use a different classification system. It's called the CPC, and it was spawned by the Europeans. It stands for Cooperative Patent Classification. Now, I'm going to be going very quickly here, but if you visit with me, I go over in more detail how you find this. But basically, you would use their classification system and find that you have children's playpens or cribs, and it seems to be correspond to a classification which is A47D 13/06. Now, one thing you have to be concerned about is the Patent Office. They joke around over there and they talk about how they speak a whole different language called patentese, combination of legal speak and engineer speak. Now, I'm sure Erin would understand a lot more about that than I would, because normal people, everyday people, don't think in those terms. Like something I would call a pencil, the Patent Office might call it a wooden cylindrical lead-filled writing implement. So when you're doing your classification searching, you kind of got to think outside the box, think about what your invention does. And if you don't find that the keywords you're using to find your classification work right away, use a thesaurus and try to think of your device from other angles. But in this case, we have a classification of A47D 1306 for our playpen invention. So I've been talking about patents for quite a bit. Let's go ahead and take a look at a patent. I'm going to try and share my screen by transitioning to the uspto.gov database. Let's hope you all come along with me. All right, can I just get someone confirm that the USPTO database is now on screen? Yes, thank you, Leslie.
I can see
Okay.
that.
Oh, fantastic, thank you. So currently, this is what the uspto.gov website looks like. Erin had mentioned earlier that you should get an account with them, which is a very good idea. If you're going to do business with the USPTO, and if you're going to go it alone, you want to get a My USPTO account by clicking on the link for that right here on the upper right. And all that's really required is an email address. And what's really wonderful about that is that you can kind of play in the sandbox and go all the way through filing an application just by practicing. And you don't have, and you get to the very end, you just don't file, pay for that demonstration. But you can practice all the way the process of filing an application for both a patent and a trademark by using your My USPTO account. Now, when it comes to searching, I like to use this Find It Fast section over here. And when you hover over patents, the first item on the dropdown is patent searching. Hey, that's wonderful. That's exactly what I want to do. But it gets a little confusing because now I have two options. I have my PAT FT and my app FT. Well, the PAT FT stands for patents full text. That was that database I had mentioned earlier with 10 million. Now they have close to 12 million patents in there. Well, great for them. But again, I want to whittle it down. So I'm going to click on the PAT FT. And I'm curious about my playpen invention. So what I want to do is I want to find other playpen inventions, get a whole list of them, and then cull through them piece by piece to see if anyone's beaten me to my technology. And this is the template here. Well, what am I going to enter? I'm going to enter that classification I had found earlier. This time, I'm not going to put any spaces, just A47D 13/06. Now, I have to tell the database what that means. Over on this next field, I use the dropdown, and this is a good look at all the different types of searches you can do. Now, remember, we want to do a classification search, and the classification we're using is CPC. So I click on CPC here. Over here, I have what's called a Boolean operator. I have choices of and, or and not. This will be good later when you have a little more experience and you want to really build upon your searches. For now, I'll leave that blank. I'll just leave it as and. Over here, select years. Now, people do enjoy doing their keyword searching, so it's defaulted to 1976 to present. But let me tell you why you want to use that other option, 1790 to present. Because in my case, I'm looking for playpens, and playpens have been around for a very, very long time, well before 1976. So I am interested in finding those patents way back then. Even though patents only last for 20 years, once a patent is patented, you cannot patent that technology all over again. You can, in fact, patent improvements upon your playpen, but you cannot patent the playpen all over again or any previous improvements that have been patented. So I do want to find those. So now that I have my classification for playpens, and I've told the database where to look for that, and I've selected my years, I'm going to click on search, and the database is going to return 210 patents that have to do with playpens. Great, not that big of a number. If it had been 2,100 patents, then perhaps the classification I'm using may be a little too broad. But what I want to show you now is let's click on, let's try the travel bassinet here. And they are in chronological order, the newest to oldest. When I click on travel bassinet, and here we have welcome to a patent document. I don't know if you've all seen one before, but this is the basic layout. We have our patent number here, the inventor's name here. Over on or back over here, this is the date it was issued, not to be confused with the date it was filed. When you get a patent, you have 20 years from the file date. The file date was January 11th, 2018. Okay, so it took them a little while to finally issue that. Then over here, we have our abstract. The abstract is a summary of what the invention is. You're going to get very good at culling through these patents because you're going to look at thousands of them. maybe not thousands, at least hundreds of them. You're going to learn a lot about your industry as well. And because you have so much, and time is of the essence, you're going to want to learn how to cull through these rather quickly. The abstract is a wonderful tool for that purpose. Then you scroll a little further, you'll have what's called the assignee. I would think it would be pronounced assignee, but I guess the patent office has a little bit of a sense of humor. And the assignee is actually the owner of the patent. So there's an inventor, and then there's an owner of the patent. So what that means is when you get a patent, it's property. You can will it to your next of kin, you could sell it, you can license it. In this case, this gentleman, Mr. Andrew Horst, is probably licensing it or sold it to Wonderland Switzerland AG. So great for him, he's making good use of his patent. The assignee, sometimes you have trouble finding a classification, but you know of a competitor that has a playpen that's similar to yours, and you want to find what classifications he's using. A little later, if I had time, I'll show you. You can do a search by assignee to find out your competitor's patents, and then you can kind of reverse engineer and see what he's doing. I know I'm cutting close to, I'm getting short on time. So really quickly, we have our Cpcs classifications. These are the classifications. And sometimes you'll see there are several more than you had written, than you had used. And that's because the invention may have many more different functions than anticipated. References cited really quickly. When you're doing a patentability search, you're going to be taking notes as to any patents that are similar to yours, and you're going to take notes of the patent number, when that patent was filed, and the inventor. And as part of the patent application process, you're going to include a document that includes all of these patents that you had found. Incidentally, if you feel this invention by Mr. Horst is similar to yours, you may want to click into all these patents as well, because he found that these inventions were close to his. So next we have the patent claims, which is kind of the meat and bones about what it is you're trying to get protected. And after that, you have the description of the patent, where it's kind of the inventor's argument about what their invention is, the summary, and why it should exist. Now, in the interest of time, a lot of inventors would like to go straight to the image. You've heard the expression, a picture says 1,000 words, and I agree. So a lot of inventors will go straight to this link, and when they do, they're going to get the image, an actual scanning of the actual patent. Now, the reason that's helpful is because it'll include the drawings. So over here on the left, I have this menu. I click on full pages, and a lot of inventors will like to go straight down to the drawings, and sometimes it'll give you a really quick idea if this is an invention that is very similar to yours, and if you want to read further into it. Okay, am I still on screen? Yeah? Okay, good. So I promised I would put my contact information back on the screen. I'm going to do that just now. So I just want to thank everyone for listening and for being involved on this presentation. This is my contact information at the Smithtown Library. You can call me, you can email me, you can even visit, but please call first. And again, I don't charge for my services. I can perform a demonstration of the patentability search for you, or a demonstration of the trademark electronic search. Or if you have any questions, I'll do my best to answer. But again, I do not answer legal or business questions. So I think we can, Leslie, we can open it back up to the group with Erin and see if there are any questions we can answer.
Yes, we have questions. Oh my gosh.
Oh, fantastic.
We definitely. First thing, yes, the recording will be shared. Second thing, the speaker's contact info will be sent to you in a follow-up email before lunchtime tomorrow. So don't worry about if you weren't able to copy and paste it. Let's go all the way back to the beginning. We're going to start with Jacqueline's. She says, how is infringement determined in trademark copyrights and especially in patents? She's designing an electric motor and she's planning to manufacture the design here in the US. How does she make sure that she's not infringing on older designs? I think Bill might have answered that. And if she does, and her product needs to properly operate, what are her options?
Well, I would, if she has found patents that are similar to hers, first thing she wants us to find out is if the patent has expired, because once it has expired, that technology is free for anyone to build upon. But if it has not expired, then she may want to seek legal advice, because this would be very specific to that invention. I don't know how much different hers is from the previous invention, but maybe Erin could expand upon that.
Yeah, I would recommend conducting a patentability search first, determine if there are prior art, if there's anything that would be a red flag that may come up that is similar to your invention, and then go from there in terms of whether or not your invention reads upon the claims of that invention that is still active. So I would start with a patentability search first to determine if there's anything out there, and then go forward from there in terms of whether or not there is an infringement. An infringement really depends on your invention and to the claims associated with any active patent out there.
Okay. We have one from Dr. Velazquez. How does copyright work for a faculty member as author of journal articles or books? Can the individual keep the copyright, or does it go to the university and is considered, quote, for hire, as the person is employed by them?
Yep, so that would depend on the relationship with the university, whether or not that individual is an employee of the university. If that person is an employee, then technically the work belongs to the university, and all works that are conducted as an employee during company time, during company resources, that belongs to the university. However, in an independent contractor situation, that potentially may be different if it was created in his or her own time, using different resources. So it all depends on the individual situation that needs to be delved into a little bit deeper. But if it is an employee situation, this person is an employee of the university, using university time, resources, and so forth, that technically is university property.
Yeah, if I could piggyback on that, there's a group called the National Inventors Center Club, run by a friend, Brian Freed. One of the guest speakers he had recently was Martin Hooper. Martin Hooper was the invention of the cell phone. He worked for Motorola, and he wasn't complaining, but he said he got paid $1 for the invention of the cell phone because he was under contract, and whatever he invented on the contract on their time and their equipment belonged to Motorola. But he had joked that he got paid an extra $1, but he made us very aware that he was well compensated for his invention, however.
Okay, Carolyn is asking about copyrights. In the case of an artwork, and she's directing this toward Erin, you said it is a tangible media and copyrighted once, for instance, a drawing is drafted and finished on paper as soon as it's created, just to emphasize that is even without being published, but for stronger enforcement of the rights in regards to publication, is one's own website or social media sufficient?
Yep, so publication is not required in order to obtain copyright protection. So the work can be published, or it does not have to be published. And you can apply for registration of that copyright as a published work or an unpublished work. So your rights are the same. It does not need to be published in order to obtain copyright protection.
Okay. Jacqueline asks, can you patent a design similar to an existing patent, but under a different classification or purpose? I think Will might have answered this. Her thinking is, what if you ended up with a design too similar to an existing patent, but the patented design was meant for something else?
Yeah, that one I would defer for her. I would advise her to get legal advice. Again, I can't get legal advice, and I'd have to see what the particulars are, and yeah, I would definitely defer unless everyone wants to chime in. Sorry, Erin, if I put you on the spot, but
No, it's that is something a little bit more involved that I don't believe we're able to answer at this time. It really depends on the situation, and if you're looking to create something that is similar, then maybe there is argument that it could be patentable, or it does not infringe the other product, but that is a little bit more involved that that we cannot opine upon right now.
Okay, I see we have some people who are leaving. So I'm going to ask Bill Z to please speak a little about the SBDC, and that because we can help with some of these questions and funnel people to Will and Erin as needed. And then we'll get back to the questions. Bill, can you do that, please?
Yes, thank you, Leslie. First, I'd like to thank Erin and Will for a very informative and presentation. Very well done. And to talk a little bit about what we do at the Stony Brook Business Development Center, we offer free and confidential one-on-one consulting. All of that work is performed by certified business advisors. And it is very important to emphasize the confidential nature of what we do, because a lot of times when we're working with businesses, we find out a lot of the details about that organization, and that is not shared with anybody. The areas that we assist organizations with, we actually cover everything from starting a business to growing a business to running a business, your online presence, various certifications to include minority and women-owned businesses. We also help organizations get contracting with federal and state organizations. And as you can see, we present a lot of workshops. This is an example of one of them. A lot of the ones that we have presented have been recorded, so you can go back to them and review them if the subject matter is of interest to you. And additionally, we are working with a lot of organizations to find funding and the grants that are available to them. And we have recently increased our initiative in the Hispanic area. We have a lot of our work is being offered in Spanish and also being translated in Spanish. And we are involved in various competitions to supporting people develop technology. And basically, when you get the information from this, Leslie, I believe there will be details of how to contact us. Is that correct?
Yes, that is correct.
Yes. And I also, before I sign off, I want to acknowledge Leslie for all the work she did behind the scenes in supporting this organization, this workshop. And it was a very fine job. So thank you, Leslie. Okay. Now, I guess are we going back to the questions? I think you're on mute, Leslie.
Yeah, thank you. Oh, here's a good one, because I have a question too, but I'm going to let everyone else's go first. Myers is asking about phrases or sayings that she wants to put on merchandise. Is she protected from the list she has in her notebook since they're written down? She's searched the phrases to see if they come up anywhere, but have been reticent to start as she doesn't understand what would stop others from stealing the phrases.
Okay, that would be protectable under trademark laws. You would have to either apply for registration or use those particular phrases on your goods, or it looks like merchandise right here, on your goods, in order to secure common law protection. The list itself, if it is not used, if those phrases are not used in connection with your merchandise, that is not protectable. This is because trademark rights are given to your use of those particular phrases on goods. So the list itself although you may have come up with good phrases, they're not used in connection with those merchandise. So they are not protected under common law, and also under federal trademark laws. You would have to apply for registration or use those marks in commerce.
Okay, Michelle's company is coming on as an independent. Oh, my company coming on as an independent contractor with an organization to offer educational consulting and doing videos that will live on their platforms. I think she means the organization's platforms. Is there anything that she needs to be aware of before signing the agreement? She'll also be creating courses, guides, and how does she protect them? Is it enough to say that the item is the intellectual property of my name and my company, or should I just use the C? I'm not sure what she means by the C.
As to the first part of the question, in terms of signing the agreement, it really depends on what the terms are that is laid out in the agreement. We can't really give legal advice as to whether or not that's something that can be signed or not. As to the second portion of it, in terms of it says
Creating courses and guides, yeah.
Creating courses and guides in terms of protection, you are protected under common law copyright. Once you create those courses, you can apply for registration of those courses that you created. In terms of the use of, I believe, the symbol, the circle C, that is not restricted in terms of whether or not they're registered or not. You can put the circle C on your course material, anything that you independently created that is deemed your work. Formatting does not matter. You see sometimes that some people put the date along with their name. You can put that on there. There's no requirement that you put that on there. You don't lose any rights by not putting the circle C, but it is a good idea because it gives the public notice that it is your work and you do claim rights to it. So use of the circle C is recommended for any original works that you create.
Leslie, I think you're muted.
Of course I am. Can a trademarkability, sir, thank you, be done through the USPTO website, or must it be done through the Library Resource Center? And does the search itself give rise to a potential infringement claim?
The searching can be done anywhere there's access to an internet. Of course, you want to search the USPTO.gov database called TESS, Trademark Electronic Search System. One thing to keep in mind is the Trademark Electronic Search System, it only has federal registered trademarks, and there are common law and state level trademarks as well. So it will behoove anyone who is interested in protecting a mark, not only to search the Trademark Electronic Search System for federal trademarks, but also look in state level or anywhere you think that your products can be marketed, just to see if someone had beaten you to that mark in your industry. There's a lot of mom and pops and startups are not even aware of intellectual property protection, but they do still have rights.
Thank you. And Rip Bowman, did what Will just say answer your question sufficiently? Yes or no?
Yes.
Okay, good. Thank you. All right. Raina asks, would you protect your art the same way?
I think that'd be a copyright.
Yeah, yeah, it would be. I'm not sure what that question is, but I think that's you're asking about copyright protection for art, and it would be the U.S. Copyright Office for that protection.
Okay. And Lila, we're going to send you information on how to become a client so that you can talk to our business advisors free of charge. Oh, and Michelle, the C is the circle, the symbol in the circle. Okay. My question is this, and it's really tacky, but it's really touchy. Sampling. Musicians do a lot of sampling of other musicians' songs in their own songs. Is that something big and ugly that you guys don't talk about or won't handle? Or what about that?
Sampling in terms of using the same musical compositions, lyrics, what are you referring to when you're saying sampling?
There are songs out there. I just had the title of one. I thought I had written it down, but I didn't. That actually takes snippets of another song and integrates it into theirs, lyrics and all. I think there's one called Don't Go Chasing Waterfalls, and it actually has a sampling from an older song, like from the 60s in it. And I know a lot of musicians were getting very upset that other musicians were sampling their songs, putting it in the background, that sort of thing.
Yep. So that type of law is very murky. It is technically considered a copyright infringement. You're taking lyrics, you're taking the composition, how it is arranged, and using it as your own. So you do have to obtain permission from the copyright owner to use that particular song, lyrics, and so forth. I did work on a certain matter for a marketing company who wanted to use snippets of songs for their presentation. You do have to get permission from the copyright owner or the clearinghouse that has rights to licensing to get permission to use that song in your presentation or in your store, anything like that. You do have to get permission from the artist or the clearinghouse, whoever owns rights to that musical work. You do have to get permission to use it.
Okay, thank you. And Carol came up with another question. We're getting close to the 10:30 mark, people. This is really great. Does the search itself actually give rise to a potential infringement claim if you find that a phrase that you have been using is used by someone else? That sounds like it was going back to the other question about putting phrases on merchandise, but maybe there's something a little different.
So searching itself would not give rise to a potential infringement claim. It's not as though your searches are monitored or seen by anybody else. That would be a little scary if somebody were to see all my searches that are conducted on the site. So no, feel free to search the USPTO website to check to see if your mark is available. Take a look, do a deeper dive to see if the goods and services are the same. Check to see if the registration is active. Do a Google search as well in terms of common law searching of your mark to see if there's anybody out there who have not registered their mark but are using the same mark as you are in connection with the same goods and services. So feel free to do your due diligence on the USPTO website, on state websites, and also on Google to see what is out there. So don't be afraid to search. Because nobody is, there's nobody recording you or watching you in terms of your searching.
Okay, and we'll just do this. Carol Russell, I'll send you the answer to that question. Myers, this is going to be the last question. Myers, she wants to know where did she go? If she could use the Circle C on her phrases. If the phrases came from a piece of writing, would they not fall under copyright law versus trademark? She was going to trademark the names she has for the categories of mercy, trying to understand the difference between the two. Would art on the t-shirts change the trademark versus copyright? And she's got like 4 questions in there.
Well, if it's a trademark, it's going to be it'll be on the product. If she's got t-shirts, is it you said?
Yes.
So she's got like, let's say a logo on all of her t-shirts that appear on the shirt collar or on the shirt. That would help the consumer know who is the source of the product. That would be a trademark. But
No,
if her
that's not what I'm talking about. I'm sorry. I was trying to type as fast as possible. I'm sorry to interrupt. I want to
No,
stream
go ahead.
for you. So this is many of these phrases are coming from writing that I've done, my own personal writing. And so now I want to take these wisdoms and put them on different things. So say on a coffee mug, instead of a zip code, I want to have one of my wisdoms that have come from my writing. So that's why I was thinking it was copyright and versus trademarking, where the snazzy name I have for the t-shirt line or the mug line would be trademarked. I'm trying to understand how I protect the phrases. So I'm
Yeah,
not
I think you are
understanding-
correct. I think you are correct with the copyright for the different mugs and different t-shirts. If they vary, they're different ones. You can copyright them all.
and then trademark the name of the.
Yeah,
what I
trademark the name that the customer would recognize as the source of the product.
Got it. Okay. Thank you.
Okay, we do have many other questions, but I think Erin and Will have to leave us now. So I'm not sure. You two don't have time for more questions, do you?
I can't speak for Erin, but perhaps one more.
Yep, I can do
Okay.
one more.
Okay, let's see. Oh, no, Raina, this one's going to take a long time because I dropped this question on them before. What about app or software development? What's generally patented and is it concept? She asks because many use the same Cody tongue. I'm not sure what that is to develop them. Raina, do you want to unmute and ask them this question?
Morning. Thank you for taking my question. I'm just curious, since so many software developers use the same types of code to develop apps. So what exactly are you patenting when you have an idea or a new concept? Is it, I mean, are you protected because you're using the similar, you have a unique concept, or can you not use a trademark if you're using code that everybody else is using? I may be completely off on this question, but what is your guidance?
That is a tough one. It's a whole, I think that we're learning a lot more every day about how trademarks and software work. I think my understanding that the software has to be reduced to some kind of function that you can witness rather than just algorithms being patented. You can always copyright any code, but I would again refer to an attorney if you've got one to be able to better answer that question.
Yes, so in terms of the code, as what William said, that is subject to copyright in terms of your source code, your object code, and so forth. That would be a copyright protection. And then in the operation of the software, the method, that may be subject to a method patent, but that is that's something more involved that you would have to seek legal advice to determine adequate levels of protection for your invention. Leslie, you're on mute.
Thank you. I have something going on in the background. Michelle would like to know, would it make sense to trademark her company name?
Does
Yes.
that make sense? Yes.
If the business name is what appears on the products, lots of businesses have a business name like Procter and Gamble, but they have several trademarks like Ivory, Soap, or Dove, or what have you. So whatever is appearing on your product would be the trademark.
Okay, we've run over and we want to value our speakers' time. So thank you all very, very much for attending. As I said in the chat, you're going to get an evaluation as well as the speaker's contact information. Thank you all so very much for attending. Stay safe and well.
Thank you, Leslie.
Okay.
Thank you, Bill.
I'm going
you.
to end the recording, and I thank you guys, as I said before, I thank you so much for having done